Cast is now starting. All attendees are in listen-only mode.
Good afternoon and welcome to Know Before You Bid. I am Nichole Atallah, and I lead our labor and employment group here at PilieroMazza. I'm so glad everybody is with us today. And I'm here with my partner, Peter Ford. He is a partner in our government contracts group. He also does a lot of corporate and small business work. And again, welcome to the presentation. So today we're going to talk about a number of things, and you are welcome to ask questions throughout the presentation. If we can get to them during that slide, we will do so. Otherwise, we'll answer questions at the end, but please feel free to submit questions on the questions panel as we go through the slides today. If you have a question that's pertinent and has a lot of facts that are specific to your organization, and you would prefer to send them via email, our email addresses are on these slides, or you can visit our website and get our email addresses, and we're happy to answer any questions that way as well. PilieroMazza is a full-service law firm here we're located in Washington, D.C. Peter is out in our Boulder, Colorado office. So if you hear a little bit of feedback today, it might be because we're in two different locations, but we hope that any feedback is at a minimum today. So what we want to talk about today is the issues that we see as lawyers that ultimately arose pre-proposal. And we want to talk about why this matters. We're going to talk about some set-aside issues that we see that can be avoided if you've handled things at the pre-proposal stage, what considerations you need to think about for joint venturing, what you should think about if you see solicitation defects, some wage and hour concerns, and that would include some prevailing wage laws. We probably won't get to everything today, but these are some of the big hitters that we see, and we thought it would be nice to have a discussion with you all about how to avoid some of these problems if you're thinking about these issues when you bid. So what does legal have to do with it, right? So why involve a lawyer prior to submitting a proposal? Well, a lot of these issues arise in the protest phase, so either the award that you were awarded is being protested by somebody else, or you would like to protest an award, and we're thinking about what grounds that you have to bring that protest. This comes into play during contract disputes, sometimes in teaming agreements, subcontract agreements, and also contracts with the government. So if there's some sort of dispute about performance, or about the cost of performance, or how things are billed, even sometimes False Claims Act cases, the actions that were taken prior to engaging in this work can really matter. It also matters when it comes to equitable adjustments and what kinds of funds that you can recoup in an equitable adjustment phase. Wage and hour complaints, obviously, I'm a labor and employment attorney, so I see a lot of this type of issue with wage and hour, and we're often looking back to the way the solicitation was issued and how we bid and how we looked at those positions in a contract. So that's why legal is really important even in the pre-proposal stage. So now I'm going to hand it over to Peter to talk a little bit about verification of size and status.
Thanks, Nichole, and good afternoon, everyone, and thanks for joining us today. One of the things that Nichole mentioned at the beginning that we're going to discuss is set-aside issues. Obviously, if you're considering going after a contract and bidding on that contract, and that contract or that opportunity is set aside for small businesses, or if it's set aside for a specific small business category, you obviously want to make sure that you're eligible to bid, meaning you vetted your documents and you confirmed that you are in fact an eligible STVOSB, or you've looked at your tax returns or your payroll information and you've confirmed that you meet the applicable size standard. And if you've ever been the subject of a size or status protest, you know it's a stressful, time-consuming process. You have to provide the SBA with a wealth of information in a very short amount of time, and I mean this can consume days worth of your time that you could otherwise have spent running your business. So even when you prevail or found to be small and you get to keep the contract award, the victory may not taste so sweet. So now just imagine how it feels to put the brakes on and running your company for several days, likely more actually, only to be found large and have your contract taken away from you. Awful, as you can imagine, which is why verifying your company qualified as a small business for the size standard, or that you meet the eligibility requirements for the applicable small business category, SDV, OSB, HUBZone, women-owned small business, etc., is critical to your bidding strategy. And one way to do this is to conduct what we call an internal review. And it's an internal review of your size and or status that is accomplished by thoroughly assessing your current size and status reps and SAM to see if you get a clean bill of health or if you identify issues that you need to address before submitting the bid. And if you haven't done this before, you should do it now and update at least once a year. What you don't want to do is wait until the day before your next proposal is due. Otherwise, if there are problems, it may be too late to address them. And an internal review really is more than just looking at your tax returns and your payroll records. And we would advise to treat it almost like a mock size determination, meaning complete what is called the SBA Form 355, which is an application for a small business size determination. In addition to letting you know where the company stands in terms of average revenue over the past 3 years or employees for the past 12 months, the 355 will identify outside business interests of the owners, officers, and directors of your company, which may be potential affiliates. You should also review your corporate documents to see if there are any provisions that are problematic from a negative control standpoint, and look at existing contractual relationships and revenue breakdown by customer to determine whether there's an economic dependence issue. And if you recently acquired a subsidiary, you would definitely want to know how that acquisition is going to impact your size moving forward. Next slide, please. You may also want to consider implementing a policy and procedures for verifying your size or status. For example, your policy could be to adhere to the laws and regulations for the small business programs, ensure all of your size and status reps are 100% accurate, and that you will take quick action to rectify mistakes. And you can make that policy part of your company's mission statement and drill it home to your employees so that everyone is aware of how important it is to confirm that you qualify as small or for a specific small business category before you submit that bid. Your procedures for verifying size and status, could address a number of items. You could pick a date for doing your annual updates of SAM and other online databases, and you could clarify the size and status verification procedures for each bid, meaning you're going to check SAM to make sure that your reps are accurate. You're going to confirm that your revenue or headcount is below the size standard, and you're going to determine if any triggering events have occurred, and I'll get a little more into triggering events in a minute or two. You could also specify a person who's going to be in charge of handling the initial verification, and then provide escalation procedures for internal and external review when the initial verification is unclear. And you can also implement steps for documenting your interpretations of SBA's affiliation rules and circumstances. And I'm sure many of you know, as a small business government contractor, your biggest asset is your small business status. So you do need to understand SBA's affiliation rules. And at the end of the day, affiliation is all about control. Some situations may be clear-cut, such as common majority ownership of multiple firms, but many situations will have at least some gray area. Identity of interest through economic dependence, familial identity of interest, the newly organized concern rule, and a sensible subcontractor. Next slide. So I just mentioned that your verification procedures for each bid should include making a determination as to whether a triggering event has occurred. So here are some examples of triggering events that we see come into play on a pretty regular basis. So bringing on a new owner. So if you brought on a new owner, even if he or she is a minority owner, you should confirm whether that individual has any outside business interests that could be potential affiliates. if you went through a merger or acquisition, you need to know how that transaction affects your size. And if you're a partner to one or more joint ventures that has been awarded contracts, you need to properly account for your share of the joint venture's receipts. And other things to think about are, have you started doing business with a company owned and controlled by an immediate family member? Or does your customer revenue breakdown show that you're getting 70% or more of your revenues from a single source? And if the answer to either of these questions is yes, you probably do have an affiliate. But do keep in mind that affiliation is only a problem if, when combined, the two companies are large. Having said that, unwinding an affiliation problem is rarely a cakewalk, so you do want to avoid it if you can. So a risk analysis is really another component of your verification procedures, and it comes into play for new projects and new business partners. For new projects, you want to make sure that you can do the primary and vital requirements as the prime contractor, and that you will be able to control the project. And with respect to new business partners, you need to assess this risk at the teaming agreement stage. Meaning, if you're depending on your partner's size or status, what have you done to verify that the size or status of your partner is what they're saying it is? And how comfortable are you with that statement? And at the end of the day, I mean, if the results of your analysis show that the risk is simply too high, I mean, you may just want to forego bidding on the contract opportunity. I mean, think about it. I mean, why waste time, effort, and money preparing a proposal when you have a strong feeling that you're not even eligible to bid? And then there's also what's called the presumed loss rule, which is all the more reason to verify your size and status before submitting a proposal. This rule says that for set-aside contracts, there's a presumption of loss to the government based on the total amount expended on the contract whenever it is established that a firm willfully sought and received the award by misrepresentation. And if you think about it, the amount expended on the contract, that's the value of the contract, and that's a hefty penalty. And the submission, meaning simply submitting a proposal for a set-aside contract, is considered an affirmative, willful, and intentional certification of your size or status. That said, the presumption of loss penalty may not apply if the misrepresentation was the result of an unintentional error, technical malfunction, or other similar situation that demonstrates that it wasn't affirmative or intentional or willful. But again, I mean, why take the risk when the penalty is so substantial? Just don't bid the project if you haven't verified that you are eligible and able to make an accurate representation. And then be careful what you advertise. And what I mean by this is it doesn't take much for someone to file a size or status protest, meaning they only need so much information. And I would think more often than not, most of the information that people use to file a size or status protest is information that's publicly available, and they get it simply by doing a Google search, or they're looking at your website. And if they're looking at your website and in your news section, you are discussing recent contract awards of $50 million and things of that nature, or if you have a section discussing your team, so to speak, and you're listing 15 to 20 individuals, someone, and we see this happen all the time. Someone can go ahead and just start Googling the names of those individuals or looking them up on LinkedIn, see if they have any outside business interests, meaning what else are they doing outside of your company. And all of that information is sufficient for someone to lodge and file a size or status protest. So I'm not telling you to take down your website. Just be careful in terms of what you put up there, because at the end of the day, it could be the basis for someone challenging your size or your set-aside status. Next slide, please. So teaming and joint venturing. Both of these are advantageous in that they allow you to submit a more competitive bid. You can combine your resources with those of your teaming or joint venture partner and enhance your capabilities. But again, you need to be careful how you approach and implement either of these bidding strategies. With teaming, the relationship between the prime and the proposed sub is laid out in the teaming agreement and the resulting subcontract. And your teaming agreement needs to be very specific in terms of the roles and responsibilities of both parties. you should be assigning discrete contract tasks to both the prime and the sub so that it's very clear as to what each party is going to do on the contract. And if it's not, meaning it's not crystal clear that you as the prime are going to be performing the primary and vital requirements of the contract, you can run into an ostensible subcontractor problem. If you don't know what the ostensible subcontractor rule is, it's an affiliation rule where SBA will find that a sub is affiliated with the prime if the sub is performing the primary and vital requirements of the contract, or the prime is otherwise unusually reliant on the sub. So if your proposed sub happens to be a large business, obviously a finding of ostensible subcontractor affiliation is going to blow you through the size standard and result in a lost contract award. I should point out that this rule does not apply to a similarly situated entity, which is a sub that has the same small business program status as the prime contractor. As an example, for a HUD zone requirement, a subcontractor that is a qualified HUD zone small business concern would be similarly situated. Next slide. So joint venturing. So for joint ventures, the roles and responsibilities of the JV partners are described in the joint venture agreement, similar to how you would describe the roles and responsibilities of the parties to a teaming agreement. Under the rules, meaning SBA's rules, a JV qualifies as small so long as both parties, meaning both JV partners, are small for the applicable size standard. So again, prior to negotiating a joint venture agreement, you need to confirm that both you and your JV partner are small businesses. And obviously, if you do an internal review and you find out or confirm that you're small, that's great. But at the same time, the JV is only going to qualify as small if both of you do. So you need to make sure that you're getting all the information from your JV partner, or at least getting a written representation from your JV partner that they do in fact qualify as a small business for the procurement. In addition, with the exception of a JV agreement between two small businesses pursuing a small business set-aside, a JV agreement for a set-aside contract, meaning 8A, SDVOSB, woman-owned small business, etc., must contain a number of required provisions, and those provisions are found in the SBA's regulations. For example, the agreement must state that the qualifying JV partner, which would be the 8A firm, for example, will be the managing venturer, and that an employee of the managing venturer will be the project manager. In addition, the agreement needs to detail what each party is going to be bringing to the table in terms of resources, meaning what resources are the parties going to contribute to the joint venture to perform the contract. And you also need to specify the specific contract tasks that each party will perform. And I say specific because specificity is key, unless you are pursuing an IDIQ or MAC type contract, in which case general descriptions will suffice. And just keep in mind, if you get protested, meaning your joint venture wins a contract award and someone files a size or status protest, the first thing SBA is going to ask for and review is the JV agreement to ensure that it contains all the required provisions and additional information. And if it doesn't, the JV is not going to be found eligible for contract award, and again, you're going to lose the contract. So the point is, you need to make sure that your JV agreement is fully compliant. So one, it's a matter of making sure that the provisions that are required by the regulations are in there, but at the same time, JV agreements don't get put together overnight. There's a back and forth negotiation type process between the two JV partners. So it's in your best interest to start that process as soon as you can, meaning once you've identified the bid, once you identify your JV partner, so you're not waiting until the last minute to get your JV agreement finalized. In addition, a JV has to have its own tax ID and DUNS number, and it has to be registered in SAM. So again, these items are not going to be accomplished overnight. And the SAM registration alone, I'm sure you all know, that can take at least a week. But these are items that do need to be taken care of prior to submitting the bid. So again, similar to getting the JV agreement finalized, don't wait until the 11th hour. And you also need to review the RFP solicitation to see what it says about JVs. For example, the RFP may require that the JV agreement include information in it above and beyond what's required under the SBA's regulations. And if it's an 8A contract, the RFP might require that the JV agreement be submitted to SBA for review and not necessarily approval at the time of bid submission. And as a side note, if you are going after an 8A contract as a joint venture, I would recommend that you give your BDS a heads up and confirm what documentation they're going to want to see to approve the joint venture and exactly when are they going to want to see it. You could also have a RFP that has a security clearance requirement. And what if it says that, or does the JV need to have the clearance itself, meaning the JV entity, or will the clearance of one or both of the JV partners be sufficient to meet the requirement? And likewise, what if the RFP says that the JV itself must have recent and relevant past performance, and that the past performance of the individual JV partners is not going to be considered? That last one is actually what we would call a solicitation defect, because SBA recently, not recently, but in 2016, amended its rules to clarify that agencies are required to consider the past performance of JV partners when considering the past performance of a JV offeror, which does bring us to our next topic, which is correcting solicitation defects.
And Peter, there's one question that I think might be pertinent to that, if we can pause for just a second. And it's about when you are trying to describe the past performance of a JV in a proposal, do you specify which work was performed by each individual JV partner, or do you just say the JV performed all of this work? I don't know if you have an answer to that off the top of your head, but I thought it might be pertinent.
Yeah, I'm sure there's probably a number of ways you could do it. I think the first thing I would do, maybe in the intro, is make very clear that the SBA's rules require the agency to look at the past performance of the individual JV partners, just so that they know when they start reviewing your past performance proposal that they shouldn't be focusing on the JV entity itself, and they should be looking at the past performance of both JV partners. So I think one way that you could do it would be when you're, let's say that you have, 3 past performance examples. One is from the, let's just call them the 8A partner, and one's from the two are from the non-8A partner. I think you could just describe it as a contract performed by the 8A partner, and then in parentheticals, just note that this company is the managing venturer of the joint venture, and then do the same for the past performance examples for the non-8A partner to the JV.
Thanks, Peter.
Sure. So correcting solicitation defects. So this comes up when you have a solicitation that's issued for a procurement that you have been anticipating. You're interested in submitting a proposal, but there are provisions that are confusing or problematic. So what can you do? Well, you have options. And there's probably more than this, but these are the 3 that I would say come up more often than not. And the first is writing a letter to the contracting officer, where you're explaining the problem or your concern, and you're proposing a solution. And I'll be honest, this is something that we have actually found to be a very effective way of resolving a solicitation defect. Of course, it tends to be more effective when the defect is an obvious one. So with something like the JV entity having to have past performance itself, if that was the defect that was of concern to you, I think that would be an issue that would be very appropriate for the letter approach. Having said that, if the defect is not so obvious, you could file a protest at the agency level or with the GAO or the COFC. So, for example, if you didn't agree that a security clearance wasn't necessary, or if you didn't think a security clearance was necessary at all, meaning regardless of whether the JV itself needed to have it or it could be satisfied by one or both of the JV partners having it, that's probably an issue that you may want to consider protesting. You could still start by writing a letter to the contracting officer, and if it didn't work, then you could file a protest. just keep in mind that all of these are pre-award protest grounds or pre-award issues, and pre-award protests have to be filed prior to the due date of for proposal submission. So if you're going to take the letter approach, and then you have in the back of your mind that you may end up having to file a protest, you don't want to wait, until a day before the proposal is due to get that letter to the CO. You want to get the letter to the CO, let's say a week, 2 weeks out, and you could include something at the end of the letter saying that, we need to have a response no later than, the following Monday, in light of the fact that the due date is looming. And then sometimes, you can take kind of a mixed approach where you write a letter to the contracting officer, and part of that letter as an attachment is the protest that you are considering filing and that you will file if the CEO doesn't fix the issue. And just some of the, like I said, these are all pre-award issues, meaning these are solicitation defects, solicitation improprieties that all serve as a ground of protest. So some of the common solicitation improprieties that we see are, for example, terms that are unduly restrictive of competition. So this could be something like a security clearance requirement that you just don't believe is necessary, and for the agency to require an offeror to have a clearance when it's not at all necessary, and that company simply can't get a clearance, then you could argue that would be unduly restrictive of competition. You can obviously have provisions in the solicitation that are unclear or ambiguous, and you could have something along the lines of an evaluation method that's simply unreasonable. Or if you're looking at the solicitation and there's information in it, but that information is insufficient to allow you to submit a competitive proposal. And there are others, but those are just a few of them. And with that, I'm going to turn it over to Nichole.
Thanks. And a couple of questions. This kind of dovetails into my topic in wage and hour, but we see some solicitation defects on the wage and hour side that we'll talk a little bit more about in the following slides. But if you are familiar with the Service Contract Act and the Davis-Bacon Act, and let's just say the FAR clause is in the contract, but the wage determination is left out. Well, the wage determination is a critical component. So that would be one example that if a client called, I might say, well, you can try the Q&A, but depending on when the Q&A is answered, they might not give you enough of an answer. Sometimes they ignore the question completely, right? So sometimes you got to get out ahead of that Q&A and write that letter or consider that agency level protest. And one of the questions that came in was, what would be serious enough to file a protest? Well, I think what's important to know is, like, for example, in my example, where there was no wage determination attached, or there was something that was confusing about the way that something was written, if you don't protest that prior to award, you waive the right to protest that later. And correct me if you disagree from your side of the house, Peter, but if there's something that's obvious or that can be seen pre-proposal submission, and you don't protest ahead of time, you've waived your right to protest to the defect of the solicitation. And so those are the types of things that would be serious enough to warrant a protest, because then everyone is essentially on their own at that point to kind of figure out how they're going to propose if everything isn't corrected on the front end. So that's why it's so important that you be thinking about using either the letter to get things corrected, You can use, sometimes if you bring things to the attention of the contracting officer during the Q&A, that'll fix things, but sometimes it doesn't. And so you need to go to something like a letter to really bring attention to how important this is, or to go to the agency level protest, or a GAO or COFC protest prior to proposal submission, so you don't waive your right to protest, and then you kind of get what you get once you're in it.
Yeah, and the one thing I'll add is any issue or defect that we would be alleging in a letter to the CO is would be a viable protest ground, meaning it's serious enough to file an agency level protest or a protest at GAO to try to get resolved. One of the ideas behind going the letter route is there are some companies who, and I certainly understand their position, that don't want to file a protest because they have relationships with their customers, and they would prefer to try to resolve the issue without having to go and file a protest. And at the same time, the benefit of the letter approach, assuming that it's effective, is that you don't have to deal with the cost of filing a protest. And I can tell you based on experience, the cost of drafting a letter to the CO is minimal when you compare it to the cost of filing a protest, particularly if you're filing that protest at the GAO or the Court of Federal Claims.
Yeah, and a lot of this comes down to timing too, with respect to what choices that you make. So do you handle this by trying to get clarification through an RFI? Do you handle this through Q&A? Do you handle this through letter? Do you handle this from protest? A lot of it is the type of issue that you're dealing with, the seriousness of the issue you're dealing with, the legal implications if you don't get out in front of it, those kinds of things. For example, if you thought that the Service Contract Act or the Davis-Bacon Act should be in this contract and it's not, you can't rectify that after the fact. So if you don't have the time to get that clarification or to go the letter route, we may be just faced with, it's 3 days out, we haven't gotten a response from the contracting office, now we got to go with the pre-award protest. So some of this is just consulting with your advisors to figure out what we can do with the tools we have and the time we have left, and how important what's the cost benefit analysis for you as an organization. So let's move into wage and hour issues. So one of the major issues that I see from a labor and employment perspective is employee classification under the Fair Labor Standards Act. And clients will often call and say, Nichole, I'm being audited, usually by the Department of Labor at that point. I classified all of these folks as exempt professionals. And what does that mean? That means that I'm paying them all a salary, that I'm not paying them on an hourly basis, but they're not entitled to overtime. Sometimes contractors will pay even exempt employees straight time over 40, and that's okay, but they're not paying them time and a half if they're exempt usually. And the problem with some of this is that it's easy for contractors sometimes to read a solicitation and believe that a position should be exempt from the Fair Labor Standards Act. But every time you get a solicitation, your contracting team, your business development proposal team should be working very closely with your HR team or legal counsel or your HR consultants to determine whether those positions truly can be exempt from the Fair Labor Standards Act, because there are tests that go along with whether somebody can be an administrative professional or executive. Generally on these contracts, you're not going to have executive level folks, but you may have supervisory personnel that could qualify for the executive exemption, and you may have some professional staff that could fall under the professional exemption. But the professional exemption, contrary to popular belief, doesn't just mean you have a college degree. It has to be an advanced field of science or learning. We're talking doctors, lawyers, accountants, actuaries, archaeologists, architects. So it's really a high-level science background in science or learning. It's not just that you received a bachelor's degree. For example, social scientists are sometimes not considered exempt from the Fair Labor Standards Act. This subject of who can be exempt or not, I can talk about this for an hour plus. It is not an uncomplicated issue, and it's under a lot of fire at the Department of Labor now. And just by way of example, Department of Labor investigators are hourly employees. They're not salaried employees. So the first thing a Department of Labor investigator will say to you when they're investigating is, well, I'm not salaried. So how can your person be salaried, right? And that goes to those administrative professionals, too, that are extremely difficult to classify. And so if you're interested in learning more about FLSA classification, if you feel like that might not be your strong suit, we do have a separate webinar on our website, and I'm happy to talk to you about it. But the point for this webinar is that this is an extremely difficult area, and it's really critical for your entire team to be coalescing around whether these positions can actually be exempt from the FLSA. And one thing I often see is that you look at a solicitation and you believe that these folks should be exempt based on the limited amount of information that you're provided in the solicitation about any given job category. And then you get on site and you recognize that the incumbent employees that you've hired are operating very differently from the world that you envisioned when you bid on this thing. Hopefully you've been able to get some background information prior to bidding on this opportunity that gives you some insight into what it's going to be like when you transition on site. But there are a lot of times when it seems like a couple of people really aren't doing the work that you anticipated that they would be doing. And if you run into a situation where that leads you to question whether they really should be an exempt professional person or not, you need to realign that work so that it fits with the appropriate classification. When DOL walks on site, they don't care that much what the contract says, frankly. They care about what work this person is actually performing day in and day out. How much independent discretion and control do they have over their work on a daily basis? So it's really critical that you have a process in place to determine employee classification, and don't make assumptions about exemptions just because you're a professional services organization that hires professionals. Because these positions are under such scrutiny at this point, it's really critical that you take a step back and realign your processes and policies with respect to classification. You also have to take into consideration where the work is being performed. Will you have contract folks in 17 states? If you do, that means you have 17 state laws that you also have to comply with, in addition to federal Fair Labor Standards Act issues. So you have to look at whether there are any laws regarding the payout or accrual of vacation. For example, in California, you're required to accrue as you go and pay out. In a lot of other states, that's up to company policy. Does that state have sick leave laws, in addition to the new executive order on sick leave that went into effect January 1st of 2017 that might be creeping its way into your contracts at this point? There are several state sick leave laws, 17 at this point. So you need to make sure that your policies align with those state policies. What is the state you're operating in say about meal and rest breaks? None of this is covered by federal law. It's all covered by state laws. And so if you're picking up a contract where you're going to have employees in multiple locations or internationally even, you really have to be thinking about what laws are going to apply and how that's going to impact your price proposal. What is that going to do to your fringe rate? Sometimes we even get folks that get surprised by a state tax law that might affect the how much is being paid to employees or how much revenue you're making in that state, which would subject you to additional state taxes. And if you miss those types of things, that can really affect your bottom line, and it's very, very difficult to get price adjustments on the backside if you missed those things. So it's really important that you have a good labor and employment advisor, if it's in-house HR, counsel, to really talk about what are the wage and hour implications of this contract. What do we really need to be thinking about? One of the big ones that we get is independent contractors, and whether we can hire independent contractors on any particular effort. Sometimes, we get calls, Nichole, everybody down there is an independent contractor. And we got on site and we figured out that they're all independent contractors and they don't want to be employees. And it puts you in a very difficult position where you have to say, no, do they really look like employees? Are they working for me 40 hours a week? Do we provide all their computers? All of those factors that go into making a determination as to whether somebody can be an employee or an independent contractor, you have to look at in a way to protect your organization. And so there are ways that we can try to ease that transition for those independent contractors. But we really need to think about how we're going to mitigate your risk, because like employee classification, independent contractor classification is under attack at the state level and at the federal level right now. So you need to be very, very mindful about classifying correctly. The Service Contract Act and the Davis-Bacon Act I alluded to before, but we see a lot of issues around this. And some of this is because you have in the contracting office, you have a lot of personnel that maybe doesn't have a lot of experience with the Service Contract Act, maybe doesn't have a lot of training with respect to the Davis-Bacon Act or the Service Contract Act. And so we are seeing a lot of variations with respect to how to properly incorporate these into contracts and how to administer these contracts year over year. And so it's really critical when you get a solicitation that you're looking for the contract FAR clauses. So there are two places that you'll see those. When you see all of the FAR clauses in a list, it should be checked. And they should have the FAR clauses also in full incorporated into the contract. You should also have a wage determination, which I alluded to earlier. And they look a little different if it's SCA or DBA, but essentially it's a wage determination. Sometimes you'll see a reference in the body of the contract as opposed to the full multi-page wage determination attached to the contract. Make sure that if there's a reference, that it has what we call a revision number on it. So it has not only the wage determination, but it has a revision number on it. Because you can't figure out which wage determination applies unless you have the appropriate revision number. Scrutinize that wage determination carefully. Sometimes you'll see a non-standard wage determination that has different requirements for the health and welfare, different vacation requirements. Maybe it even says for this particular classification, go to another wage determination, but that wage determination is not attached and you can't find it. Those are the types of solicitation defects that we were talking about that you need to address before you bid on this thing to ensure that you have the right rates. On some of these service type contracts, your labor is most of your cost. So it's really critical that you understand exactly what that cost will be so that you're on the same playing field as everybody else. If you have concerns about whether you're on the same playing field, sometimes the Q&A is a good way to alert all of the other contractors that you see an issue. So that can be used as sort of a bidding strategy. So that's a way to some of the earlier questions about when to use what. Sometimes we use the Q&A as a strategy to alert other contractors that there might be a concern so that they don't bid it in a different way. So it's a tool that we can use sometimes. There's a lot of risk in classification errors under the SCA particularly, and sometimes even under the Davis-Bacon Act. So what do I mean by this? Well, you're often told that you've got X positions on a contract, but those positions don't often align, or sometimes don't align, with the Department of Labor classifications in the wage determination. And it's your job, and you have the responsibility as the contractor to appropriately map the jobs in the solicitation to the position descriptions on the DOL wage determination. That risk is almost completely on you. If you don't see an appropriate category, you're supposed to go through this whole conformance process to get the appropriate labor rates. And this can be a very confusing and time-intensive process. So it's really critical that if you have questions about how to map positions or whether a position can be a general clerk 1 or general clerk 2 or general clerk 3, that you reach out and get some assistance with properly classifying. What I often get is, Nichole, I know I've heard that they're all currently classified as general clerk 2s. So I'm just going to classify them as general clerk 2s. I'm going to bid it as general clerk 2s, right? Well, that might be fine and good, right? That might be perfectly acceptable. But you need to make sure that the description in the solicitation and any investigation information that you've been able to kind of procure at that point from different sources lines up that this position really should be a general clerk 2. Because again, it doesn't matter what the last guy did. What matters is what these folks are actually doing when you are awarded and performing on this contract. And if they're not doing general clerk 2 work and they're actually doing secretarial work or general clerk 3 work, you're going to be on the hook for that difference. And there's not very many ways to recoup those costs unless there was some very clear I can't even say error in the solicitation. The contracting office told you had to do something, and that's why you did it. Then we might have a recourse under the contract, but that's rare. You also have to look at, the seniority of incumbent employees. You are supposed to get a list of seniority of incumbent employees because this affects vacation and how much vacation somebody gets. It's not uncommon, and we call these anniversary dates. It's not uncommon for the predecessor not to provide that list to the contracting office, and the contracting office doesn't give it to you. So what do? A lot of contractors do some sort of blended estimate. Some contractors, if they're fortunate enough to be awarded the contract, then go out and just ask the employees. Just because you never got that list doesn't mean that you're not on the hook for the appropriate amount of vacation based on whatever date that employee might give you. So if you're awarded the contract and you get on site, you still need to try to find those anniversary dates, whether it's by asking for information from the predecessor, by asking employees for information, by trying to piece together information from other sources. It's critical that you don't ignore the seniority, the contract seniority of those employees. Don't forget that this new sick leave executive order is out there in all solicitations. It's supposed to be in all SCA and DBA solicitations issued on or after January 1st of 2017. That will impact your health and welfare rates. So if this executive order FAR clause is in your contracts, then the health and welfare rate should be 413. If it's not in your contract, the health and welfare rate is 427. So you really, again, need to scrutinize that wage determination and make sure you understand what your fringe obligations will be. Because you can know if that sick leave executive order is in the contract, you can no longer count that sick leave against that health and welfare rate. It has to be provided separate and apart from vacation and health and welfare. But you do get to pay a lower health and welfare rate. So it's really critical that you're paying attention to these details because they can really affect price when margins are already low. Don't forget that there are costs to the non-displacement rules too, that you have to make. This is the rule that was put out in 2016 and should be in these SCA contracts that say that you have to hire or provide a right of first refusal to those incumbent employees working on one of these contracts. And so be mindful that there's some cost in keeping track of who is on the contract, and you have a 90-day period from the start of the contract to go back and make any folks that you didn't make offers if a position becomes available. So just keep in mind that those rules are out there, they exist, and there are some hidden costs there. For price adjustments, it's really critical the way that you get price adjustments for the Service Contract Act. The FAR clause is 52222-43. The way that you get that is almost by attesting that you didn't put escalation in your labor costs at the outset when you bid the contract. So this is another thing that you have to pay very close attention to when you're bidding. Generally, you want to bid the wages flat. You want to estimate your G&A overhead and profit because you cannot recapture those things later. But as the wage determinations increase and are incorporated into your contract, you are supposed to get the benefit of those increases. But you only get the benefit of those increases if you didn't do your own escalation estimates when you bid the contract. So it's really critical when you go out for those price adjustments that you can attest that you did not escalate your labor rates when you bid on the contract, that you kept them flat in order to take advantage. You should also be careful and watch out for any union contracts that you see. So what you'll see is attached to the solicitation, you'll see a collective bargaining agreement instead of a wage determination, primarily on SCA contracts. There are a lot of costs in there. The union contract is called a collective bargaining agreement, and that's what's going to be attached, and that serves as your wage determination. But this does not mean that you're subject to all the terms of that CBA. You're not the company that signed that agreement, right? But what the SCA says is any wages and fringe benefits in there, you are on the hook for. So you need to scour that thing and make sure, just like you would with the wage determination, that there aren't any ambiguities in there that make it impossible for you to figure out what your price point will be for fringe, because you have to bring that up in advance. Okay, you can't do it after the fact. So if there's some reference to another agreement, like to a pension agreement or a healthcare agreement that determines your future cost, you need to ask where that agreement is. How do I get my hands on it, right? We need to know that up front because that will impact your cost. The worst thing is being surprised by all of the different benefits you have to pay for that you weren't thinking about because you weren't paying attention to the fact that there was a union contract in this solicitation. It also means that you're walking into a unionized workforce. And in that first year, you're going to have to negotiate a new contract with that union. And there are costs in negotiating them. It can be a pretty smooth process, especially if you have, if you're working with a good team at the union shop. But it's good to do a little bit of background research on the team that you're going to be working with in order to get that collective bargaining agreement negotiated in place in the base year. So you should be thinking about that at the outset. So we have a few minutes left for questions. Peter, do you want to take any of the questions that were your way? Did you see any that?
Sure. One did come in about, are we going to discuss anything about mentor-protege agreements? Unfortunately, we just don't have the time, but we do have, and I'd be happy to send you a copy of a presentation that I've done or that another attorney at PilieroMazza has done that's specific to mentor-protege, and not just the agreement, but the benefits of the new all-small mentor-protege program. The one pre-bid thing I will say about mentor-protege agreements is that if you want to bid as a joint venture, and you want to bid as a joint venture with your large business mentor, then that mentor-protege agreement, one, it should contemplate assistance in the form of joint venturing, and two, it needs to be approved, meaning the mentor-protege relationship has to be in place prior to submitting that bid. Because again, and I don't think I mentioned this, but size is measured as a specific date. It's measured as of the date that you submit your offer, including price. So if you don't have that approved SBA mentor-protege agreement in place at the time that the bid goes in, you don't get the benefit, which is the exemption from affiliation, meaning the JV can qualify as small, even though the non-qualifying partner is a large business mentor. There was a question about whether an 8A company can submit an offer on a set-aside contract, set aside for 8 days, if they're above the size standard. And the basis for saying they're above the size standard is because in SAM, they've made a representation that they are other than small for the applicable NACS code. Well, the short answer is no. If you're not small, it doesn't matter if you're 8A or not, that's a rule that applies to all of the small business categories. You have to be small to bid on a contract that is set aside for a small business category, including 8A. Why they have indicated that they are large in their SAM? I don't know. It could be a mistake. It could be that maybe the bid went in prior to the end of 2017, and they were small at that time, meaning looking at their receipts for 16, 15, and 14, they were a small business under that size standard, and maybe they updated SAM in 2018, and they were no longer small based on 17, 16, and 15. So I'm not sure why they've made that representation in SAM, but if it's not accurate and they are in fact large, then there you go. There's your basis to file a size protest. And frankly, you wouldn't have to say much. You could say that we're challenging the size standard, or I'm sorry, the size, small business size of the awardee based on the fact that they themselves are holding themselves out as a large business, and just attach as your one exhibit a copy of their SAM profile. So I think those are the ones that came in terms of my...
Yeah. We have a few minutes left, so I'm going to try to touch the ones that I think would be really beneficial for the whole group. And the first one of those is, can the administrative exemption under the FLSA apply when the staff functions are related to a client's management or general business operations? And that's yes, that the regulations specifically say that the administrative exemption can be for a client's general business operations. But again, it has to be general business operations. So it's things like finance, accounting, HR, some of the administration. So you have to really be careful about how far you stretch that. And when you start getting into the gray area, you want to document why you've made certain decisions, so that if you get a DOL investigator that disagrees with you, we have kind of the paper trail of why you made certain decisions and why it's defensible. So that's kind of where we would go with that. The next question is it mandatory for the COs to provide a federal rate equivalency? They do this for the Service Contract Act. For those of you who don't know, they're supposed to put it in there. I'm seeing more and more commonly they don't. It really only comes into play when you're trying to go get conformances for positions that are not included in a wage determination. It's good information to have. They're supposed to include it, but it's probably not something that, unless it's really critical to what you're trying to do, we'd hit really hard pre-award unless it really matters because of a conformance situation. Another question I got was, is there ever a situation where you did not escalate and the government puts an updated wage determination in the contract, but they say you're not entitled to a price adjustment? There shouldn't be. There shouldn't be. So you are legally entitled. Now, there is a timeliness requirement. You want to try to do it within 30 days, but usually there's some wiggle room there. So if you have a specific situation, come and talk to us, but you really should be entitled to that price adjustment. And the last one that I'll go over before we end today, because I think we're almost right at a time, is what do you do when the government won't give you a copy of the CBA with the RFP? And that's one of the situations where we'd really want to consider whether you should do a pre-award protest or a letter or one of those other avenues, because it's impossible to bid this thing unless you have a copy of the CBA. And I've seen that more recently, especially where the government tries to say that it's a completely new vehicle, so the CBA shouldn't apply. But that's a pretty weak argument if it's essentially going to be the same workforce performing the work. So again, that's one of those examples where we'd say, no, we really need that CBA, and we want to kind of wave our arms in the air, because you know that when you get on site, that union is going to be there waiting. And it's, you don't want to sit there facing an angry workforce because their wages have been dipped really, really low, right? So it's better if we can do what we can. There are a couple more questions that are out there. We will do our best to email you answers as quickly as we possibly can. We want to thank you sincerely for hanging out with us for an hour today. We know that your time is valuable, and we really do appreciate and value you all. And so thank you so much, and have a great afternoon.